things on that mailing that indicate sovereign citizen types of defenses that you thought you were asserting. It's not that this was junk mail. Don't make it worse. Don't make it worse by lying.
I apologize to you for maybe listening to some of the wrong information when I don't.
Well, you're a grown person, Mr. McLeod, and I hope you're learning an important lesson in civics.
Can I just say this?
You said what you wanted to say.
Before you make your decision, can I say this? Are you Wirgo? Mr. Wirgo?
No, it's Mr. Varga for arraignment purposes. All right, we are on the record in the 53rd Circuit Court for the County of Sheboygan, and we are providing public access both in the courtroom and also online, and we're here to arraign on a bench warrant Mr. Trevor Kenneth McLeod. It's file 23-6748FH. Counsel, please state your appearances.
For the record, I'm sorry.
Anthony Schumann on behalf of people.
For the record, Ronald Varga, mine with Mr. McLeod in these matters. Mr. McLeod, when I did meet with him, indicated he wanted to handle this hearing himself.
All right. Well, Mr. McLeod, it's alleged that you are in contempt of court for failing to appear on July 9th at 9:30 a.m. for a 53rd Circuit Court hearing. You've got the right to a hearing on that allegation where it would need to be proven beyond a reasonable doubt, and the right to the assistance of an attorney at that hearing. If you are found to be in violation, if you are found to be in contempt, I could jail you for up to 93 days. I could fine you for up to $7,500 or both. I can also revoke your bond if you're not complying with the terms of your release. Do you understand the rights and penalties that you have in front of you, Mr. McLeod?
I was under the impression that this was all going to be over with by now. That we're
Nope. Nope. All right, Mr. McLeod, and also, so you know the rights and penalties that I outlined for you. You understand those?
Yeah.
All right, Mr. Varga, do you know how he wishes to proceed?
No, he indicated he would enter his own plea.
Mr. McLeod, you're indicating you want to represent yourself?
Well, I thought that can I say a couple things first?
No.
Okay.
You can answer my questions.
Sure.
Are you saying you want to represent yourself?
They have been doing that the whole time.
We've been doing that the whole under Ferretta v. California, 1975, U.S. Supreme Court, defendant has the constitutional right to represent himself. He has, in this case, unequivocally asserted that right in prior hearings and validly waived his right to counsel. However, self-representation may be denied where the defendant disrupts, unduly inconveniences, or burdens the court and the administration of the court's business. That's 1976, Michigan Supreme Court, People v. Anderson. Even the Ferretta case, the U.S. Supreme Court said the right of self-representation is not a license to abuse the dignity of the courtroom. Neither is it a license not to comply with the relevant rules of procedural and substantive law. Here, while representing himself, defendant refused to accept mail from the clerk's office. When that happened, I directed staff to resend the mailing directly from the court, giving him the benefit of the doubt. Because he was representing himself, he would surely accept something from the court. He again refused, writing in red lettering on the envelope, "Return to sender, and offer to contract is denied." Defendant had someone file a document on his behalf in his case called a letter rogatory for relief, which was legal nonsense, accusing the court of fraudulently using this case as some sort of security against his trust, claiming that all judges are foreign agents and or employees of the International Monetary Fund, which is absolutely absurd, and demanding that he be placed on some non-existent do not detain list. This is not the first time that this defendant has disrupted this court's business. One time I had to hold Mr. McLeod in contempt for refusing to answer my questions during his initial waiver of counsel. After that contempt, we were able to complete the waiver process and I allowed him to represent himself. But at those subsequent hearings, he repeatedly interrupted the proceedings. He repeatedly persisted in arguments, even after being heard and ruled against. And now he has refused to participate in the court process by rejecting court mailings while purporting to represent himself. So I have now lost any confidence, Mr. McLeod, that you are able to represent yourself in this matter without disrupting the court's business or making a mockery of the court proceedings. Therefore, as this case moves forward, I am revoking your right to represent yourself, and I'm appointing Mr. Wirgo to represent you as a lawyer.
Okay, let's just do Wirgo here.
If the Office of Assigned Counsel determines that Mr. McLeod is not indigent or is only partially indigent, that office may petition this court under the applicable statute for contribution from Mr. McLeod for the costs of representation. So, Mr. Varga, you wanted to set this for a hearing then?
I do.
All right,
I do. We're not guilty.
All right, Mr. McLeod will enter a plea of not guilty on your behalf as to the contempt. So we have to schedule this for a docket call on the underlying case, which is still pending, and on the contempt hearing. I'll schedule that for August 20th at 10 a.m. I also have to advise you, Mr. McLeod, that I canceled your jury trial date and gave that date to somebody else who was here. So your trial on August 8th and 9th will not occur. I will next see you on August 20th at 10 a.m. Anything as to release Mr. Varga?
Is the court wanting to entertain a bond on this matter, Your Honor? To my understanding, Mr. McLeod is a local resident and he has met, with the exception of the last court date, that he tells me that he thought the case was resolved, although obviously it was not. He has appeared for most of his prior court dates. All. Okay. And he's employed locally, Your Honor. I think perhaps if the court would set a modest monetary bond, that would ensure future.
Make sure.
Mr. Juliet?
And I would ask that bond remain revoked. He is, what I'm told, rejecting the court's mailings of the notice to appear. I mean, I think that's just a blatant violation of
Can I speak on that?
the court rule. So he's made it clear he doesn't want to take this serious. I would ask that bond remain revoked.
All right, Mr. McLeod, is there something?
With all my junk mail, and I'm really sorry if that happened to one of your letters.
Don't make it worse by lying to me right now, Mr. McLeod. You wrote clear things on that mailing that indicate sovereign citizen types of defenses that you thought you were asserting. It's not that this was junk mail. Don't make it worse. Don't make it worse by lying.
I apologize to you for maybe listening to some of the wrong information when I don't.
Well, you're a grown person, Mr. McLeod, and I hope you're learning an important lesson in civics.
Can I just say this?
You said what you wanted to say.
Before you make your decision, can I say this? I have a job right now that's completely exposed to the weather. I've got $40,000 worth of windows coming this week to this job. I really invested in this job, and my client really rely on me. This would be a really big problem if I get this revoked. Have to stay.
Rights and freedoms, but you also have responsibilities in a society where other citizens live alongside you. That includes obeying the laws that the people pass through their representatives. For example, the people are entitled to pass a law that says they don't want folks operating boats under the influence of alcohol. You think that law doesn't apply? It does.
That wasn't.
And when a law enforcement officer sees you violating that law, you can't resist arrest without consequence. When you are alleged to violate those laws, Mr. McLeod, there's a third branch of government that does exist. And it exists for the orderly resolution of those disputes, those allegations, with full protection of your rights, as opposed to some kind of vigilante justice system. You may not agree with this, but this court has diligently tried to protect your rights and afforded you a respectful and lawful process. You have disrupted and ignored that process. You have disrespected that process time and again. That subjects you now to contempt of court and revocation of bond. Most people, Mr. McLeod, learn this lesson the easy way, but it seems that you now have to learn it the hard way. You're remanded into custody of the Chagrin County Sheriff, and will next see you, sir, with your lawyer, Mr. Wargo, on August 20th at 10 a.m.
So, can I recess?
So,
and